welcome. This is the McCarter in English inaugural podcast. Thank you for choosing to spend some time with us as we discuss the new CFIUS regulations that go into effect February 13th. My name is Zack Hadzismajlovic. I head up McCarter's Global Trade, CFIUS, and Export Controls practice. With me is Ron Leibman, who heads up our Transportation, Logistics, and Supply Chain Management practice.
Good day, everybody. Both Zack and I have been in the trade and transportation world for way more years than I like to think of. Today, we're here to try to cut through the jargon and explain to an average person who would come across CFIUS what it is, how the regs will affect them. Given that there is such a large number of inbound investments into the U.S., and we can only see that growing in the near future, this is an area all corporate warriors and transactional specialists really should become familiar with. You're a client who want to do a deal, may be questioned on this. I had a deal about 6 months ago where my client, ostensibly a U.S. company, was asked about their Australian family fund investor. You do know there's been much written about it. You've probably seen it in the Wall Street Journal and other publications. But basically, the statute, and Zack will go into this in much more detail, looks to prevent technology from being co-opted from the U.S. by unfriendly foreign governments. And with that, Zack, where do you start to explain this?
Let's start with a bit of background about CFIUS. So it stands for the Committee on Foreign Investment in the United States, and it's an interagency body that assists the president in overseeing national security risks, foreign direct investments. So what we're talking about here are really the crown jewels, right? We are looking at investments in the form of a controlling ownership in a business in one country, meaning the United States, by an entity or people based in another country. So CFIUS has been around since 1975, but it's a national security function that most people haven't heard of.
Zack, that's a fairly broad mandate for folks who are dealing with foreign investors.
Yeah, so the mandate has become even broader lately. So CFIUS used to simply review covered transactions. Now, with the advent of FIRRMA, which we'll discuss in a little bit more detail, we go beyond covered transactions and we have expanded authority, allowing the president to suspend or prohibit any covered transaction when there is credible evidence to believe that the foreign person exercising control over the U.S. business might take action that threatens to impair national security. Now, in order to exercise this authority, the president must conclude that there are U.S. laws, that other U.S. laws are inadequate or inappropriate to protect national security, and have credible evidence that the foreign interest exercising control might take action that threatens to impair U.S. national security. Now, interestingly, the president's final determinations are not subject to judicial review. So the bottom line is that the federal government had since 1975 the ability to stop a transaction from being consummated to protect the national interest. Now, with that said, since 1975, a grand total of 5 transactions were blocked by a sitting president.
Well, wouldn't you say that that was under a different legislative agenda? Today, there seems to be intense scrutiny over foreign investors, particularly Chinese investment. But the Huawei matter recently, with President Trump trying to limit their ability to do 5G in this country for fear that there could be severe security outcomes from that. So do you think the tide is turning?
Oh, sure. And it's been turning for years now. I think that our willingness to not just control commodities for export, but now to control investment by foreign parties is way different than what we used to consider a review. Now, export controls feature prominently in CFIUS review, especially with regard to FIRRMA. So I'm going to try and go back to where I think the origins of these concerns come back, and I think that's about 2016. There was something called a Defense Innovation Unit experimental report furnished to Congress at the time, where details of technology transfer or weaponized investment, mainly by Chinese actors, were detailed. And Congress at that point realized that there is really no mechanism in CFIUS that allows it to review non-controlling investments, which in 2016 evidently were used to transfer what we consider the crown jewels in all sorts of technologies that would benefit both military and commercial applications. So of that, the Foreign Investment Risk Review Modernization Act of 2018 was born, and it became law in August of 2018. FIRRMA expanded the scope of CFIUS review to include transactions that didn't result in foreign control of a U.S. business, however, had an impact on national security. So prior to FIRRMA, the jurisdiction of CFIUS was limited to acquisitions, investments, and joint ventures that could result in foreign control over any U.S. business. And FIRRMA expanded that jurisdiction to include certain non-controlling but non-passive investments by foreign persons that involved critical technology or infrastructure, or the maintenance and collection of sensitive personal data of U.S. citizens. So these are collectively known as TID businesses, meaning technology, infrastructure, data businesses.
So I think the key question for those of us who do these kinds of transactions is really, with the FIRRMA expansions on the CFIUS powers, how does the government choose which transactions to scrutinize?
It's a little complicated, but in January of this year, specifically on January 13th, Treasury issued proposed regulations that'll impact review of foreign direct investment in, among other things, certain real estate and non-controlling investments in the United States. Right. So although certain provisions of FIRRMA became effective back in August of 2018, CFIUS was required to take certain actions within prescribed deadlines for various programs, reporting, and regulations. And what will happen now is that the final regulations will be implemented on February 13th, just in time for Valentine's Day. So we have amended regulations, or will have amended regulations shortly, that allow the president to block or suspend proposed or pending foreign mergers, acquisitions, or takeovers that could result in control of U.S. businesses through joint ventures or threaten to impair national security. And then FIRRMA also shifts from a purely control-based test to now include a sensitive business-based test. So in fact, there are now two cases where CFIUS review is mandatory, and both of those include critical technology. One relates to critical technologies that were previously described in a pilot program, right, and continuing exceptions, which briefly I'll go into that. A pilot program mandated that certain covered control transactions and covered investments in certain U.S. businesses that involved critical technologies in 27 named NAICS codes, meaning the North America Industrial Classification System codes, were to have been notified to CFIUS. Now that's expanded to include these TID businesses. So if there is a substantial foreign government interest in a TID business, a mandatory declaration is required. The question I'm assuming is, what's a substantial interest, right? So it's defined as a voting interest, direct or indirect, or of 25% or more, by a foreign person in which the national or subnational government of a single foreign state has a substantial interest, and that's defined as a voting interest, direct or indirect, of 49%. So these two would be considered mandatory declarations, right? And most of CFIUS is voluntary, meaning the parties choose whether or not they need to notify government. These two specific types of transactions are no longer voluntary. They are now subject to mandatory notification.
So it seems like a TID business, stated simply, is a business that has a nexus to defense and national security. That can be construed so broadly. Does the reg at all provide any greater definition or limiters on the definition?
Yeah, to a certain extent. It's really a lot of analysis nowadays, because there are, as I mentioned, in critical technologies, there are 27 separate types of NAICS codes, so industrial classifications and businesses that are implicated. Then there are, I believe, 28 different categories of critical infrastructure. And then we also need to understand that these regs also implicate a business that produces, designs, tests, manufactures, fabricates, develops one or more critical technologies that are really defined as items that are on the U.S. munitions list, items that are on the Commerce Control List, or controlled under the Export Administration regulations pursuant to a multilateral export control regime, or for reasons related to regional stability or surreptitious listening, nuclear-related controls, emerging or foundational technologies to be controlled under the Export Administration regulations. So in short, it all relates to export-controlled technologies, technical data, and so on and so forth. So these are what we consider the crown jewels.
Thinking about it, though, does all this really change CFIUS as a voluntary process? When I have a deal, must I now, under circumstances, report where I wouldn't in the past?
Yes. So depending on who your client is and what your client does, I guess a cursory review would be to ask, do you deal in export control technologies? So if they're a target, you would want to know what kind of export control items, technical data do they deal with? Do they have any classified contracts? Do they have any government contracts that are DX or DE rated? Do they act as a subcontractor for a government contractor, specifically a defense contractor or a security-related entity contractor? These are all, I guess, threshold questions that will then inform you as to whether or not you have mandatory obligations or is it just voluntary. And sometimes parties will choose to submit a declaration out of an abundance of caution.
Zach, does FIRRMA have any exceptions that we have to consider?
So there are now exemptions as to, I guess the best way to describe them are accepted investors. And I guess we benefit from a little bit of a history here. So in November 2018, CFIUS began a pilot program that mandated filings for covered control transactions, covered investments in certain businesses, and so on and so forth. This is back to the 27 specified industries, right? Now, if some of those are transactions by accepted investors, folks from either Australia, the United Kingdom, Canada, to 3 of the 4 Five I, or 3 of the 4 foreign Five I nations, then no mandatory requirements apply. If these covered control transactions or covered investments are made directly by a company that holds active facility security clearances or that operates pursuant to security control agreements, special security arrangements, proxy agreements, voting trust agreements that mitigate its foreign ownership, control, or influence, they're also exempt. If there are covered transaction investment funds managed exclusively by a general partner who is either not a foreign person or is ultimately controlled exclusively by U.S. nationals, they're exempt. If we're talking about an investment that becomes a covered investment because the investor ceases to meet the acceptor invested criteria during the 3-year period after the transaction completion date. So there are a number of ways that one would be exempt from these mandatory filing declarations. And there are too few or too many of these to mention here or go into great detail.
So if I have a filing obligation, what is the timing of the filing?
Yeah, so this is interesting. So it has to be submitted at least 30 days prior to the completion date of any covered control transaction. And that basically, I'll give you a little bit more with regard to those timelines here. The 30 days before the completion date, parties may close the transaction prior to the expiration of the 30 days if they have been informed in writing that CFIUS has concluded all action, or in the case of a declaration, CFIUS is not able to complete action on the basis of the declaration, but CFIUS does not request for the parties to file a full notice.
So I guess the 800-pound gorilla in the room is, like anything, if it's a mandatory filing and I don't mandatorily do it, is there a penalty?
There is. So the new regulations come out with a penalty, which is $250,000, or the value of the transaction, whichever is greater, with the penalty based on the nature of the violation. Also, we should make mention of the fact that misstatements or omissions to these declarations are also subject to a fine of $250,000 per violation. So I'm not really sure how we would identify, is this $250,000 per omission, per misstatement? Either event, one would really need to make sure that they're carefully reviewing and preparing anything that they submit to CFIUS, because the potential penalties, even for just simple drafting mistakes, could be ruinous.
You've dealt a lot with the when as far as filing. What about times when folks doing cross-border deals would find CFIUS analysis not to be necessary?
Well, I guess the big exemption is now for these Five Eye countries. And I say Five Eye because there used to be a compact between the United States, Australia, Canada, the UK, and New Zealand, whereby these countries would share intelligence information, right? So for whatever reason, New Zealand was excluded from our accepted foreign state. Now we have Australia, Canada, and the UK. So if you're a national of one of these three countries, and solely a national of one of these three countries, you are what's considered an accepted investor or accepted real estate investor. And if your deal involves foreign direct investment solely from investors in one of these three countries or any combination thereof, you are entitled not to file. You can choose whether to file or not, so it remains voluntary for you.
Just to be clear to our audience, these transactions are not simply financings or M&A deals, but will include real estate transactions. And Zach, could you just give us a little background on that?
Yeah, we're not going into a great deal of detail with the real estate portion of the FIRRMA regulations. There is a ton there, but I'll just say that CFIUS's expanded jurisdiction over real estate transactions includes the purchase or lease or a concession to a foreign person that accords that particular foreign person certain in fundamental property rights. In particular, what CFIUS is interested in is real estate that's in proximity of airports, maritime ports, or other facilities and properties of the U.S. government that are sensitive for national security reasons. So they've helpfully, in the regulations, identified, I believe, about 190 facilities located across 40 states. CFIUS retains the authority to review any transactions that raises national security concerns on the basis of proximity to sensitive sites or activities.
With FIRRMA, have there been any changes, hopefully changes that would be popular with people after they do the filing to doing a CFIUS filing?
Yeah, so there is this now ability to file a short form declaration for any transaction, which is wonderful. If you've ever filed a CFIUS filing, there's a great deal of detail involved. These short form declarations are the opposite of that. It's a 5-page declaration. And the hope is that once filed, you receive feedback within 30 calendar days of CFIUS accepting the declaration. So this is an alternative to submitting a full notice and going through the typical pre-filing and formal review process. I will say that anecdotally, parties are still filing the full notice. We're not sure whether or not this is because CFIUS is requesting more information after they receive the 5-page declaration, or whether or not it's details specific to those particular transactions. But you have the option, and they can be used for any transaction. So it includes investment or real estate, any transaction notified to CFIUS. And following its review of a declaration, CFIUS may either request that the parties file a full written notice or advise the parties that CFIUS cannot complete action based on the declaration, and the parties may submit a notice in order for CFIUS to complete action, or initiate a unilateral review of the transaction, or notify the parties in writing that CFIUS has completed all action with respect to the transaction, which is obviously the best possible outcome. Ultimately, the usefulness of the declaration process likely will depend on the combination of how willing CFIUS is to conclude action by declaration as opposed to move on with a request for a full filing.
We've talked a lot about transactions affecting the United States, affecting technology, but What is the jurisdictional definition for covered transactions?
Or principal place of business.
Principal place of business, yes.
So they've come out with a new definition that I guess the nerve center definition, I think that's how I've heard it described best. So it's defined as an entity organized under laws of a foreign state, but if the principal place of business is outside the United States, the equity securities are primarily traded on a foreign exchange, that would be a foreign entity, right? However, we need to do careful reviews before just moving ahead with that assumption, because there are jurisdictional distinctions where entities that are organized offshore for tax purposes, but effectively operate within the United States, that would probably not be considered foreign entities, right? So the nerve center notion is, where is the entity's management? Where does it direct, control, or coordinate the entity activities from? And then there is a provision that states that if in your most recent filings to a government agency, other than CFIUS, the entity's principal place of business is listed as being outside the United States, then that foreign location will be deemed the principal place of business.
Zach, is there anything else that you'd like to add right now? I mean, I think it's been very comprehensive, but as an expert, I'm sure there's things you would like our audience to walk away with beyond what we've said so far.
The one piece of great news is that there are no filing fees yet. Although previously CFIUS indicated there may be, the regulations currently don't have a provision for filing fees. The commentary does note that filing fees will be subject to a separate rulemaking. FIRRMA authorizes CFIUS to impose filing fees not to exceed the lesser of 1% of the value of a transaction, or $300,000. I guess one more thing that I think is worthwhile noting is that CFIUS now has an annual war chest of $20 million. It goes to its budget, and indications were that it would use a lot of that money to not just profitably staff itself in expectations of newly notified transactions, but also to reach back and review non-notified transactions that may have security implications. So I think now more than ever is a time to make sure that you speak with your export control people whenever reviewing, include them early on in the due diligence of any deals, have them identify for you whether or not a deal may be subject to a mandatory declaration, whether or not a voluntary declaration should be submitted, and whether or not your timelines and expectations as provided to the client may change as a result.
Mentioning timelines, what is the timeline for implementation of the changes?
So the current regulations, which include mandatory filing requirements under the pilot program, will remain in effect through February 12th, meaning, well, this week, right? And then they'll apply to any transaction for which the following hasn't occurred prior to the 13th. So if they've not completed, if the transaction hasn't completed prior to the 13th, the old rules still apply. The parties to the transaction executed a binding written agreement or other binding document establishing the material terms of the transaction, old rules still apply. If a party has made a public offer to shareholders to buy shares of a U.S. business, old rules still apply. Again, if that occurred prior to the 13th. Or if a shareholder has solicited proxies in connection with an election of the board of directors, or an owner or a holder of the contingent equity interest has requested the conversion of contingent equity interest prior to that date, old rules still apply. However, transactions subject to the mandatory filing requirements under the new regulations beginning February 13th, you'll have to submit a declaration, written notice in lieu of a declaration, no later than February 13th, 2020, or promptly thereafter, if the completion date of the transaction is between February 13th and March 14th, right? So 30 days prior, or at least 30 days before the completion date of the transaction if the completion date is after March 14th, 2020.
Zach, thank you very much for a detailed and interesting dialogue on this very important new reg. And thank you in the audience for listening to us. If by any chance you have any questions, I'm sure Zach or I would be more than happy to answer them. One of the things you will now learn is how to spell Zach's last name, which I'm not even going to take a shot at. So, Zach, why don't you give these folks your email address?
So thanks, Ron. Thanks for suffering through this with me. We're both kind of reluctant hosts here. My email address is zh@mccarter.com. And Ron?
Mine is RLEIBMAN, also at McCarter, MCCARTER.com. And both Zach and I are located in McCarter's New York office. Again, thank you so much and have a good day. This McCarter and English podcast cannot be copied or rebroadcast in its entirety without consent. The information provided is intended for a general audience and is not legal advice or a substitute for the advice of competent counsel. Prior results do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this podcast, and all rights are reserved. Thank you.